All right, U.S. Department of Transportation, Pipeline Hazard Material Safety Administration. This is the Pipeline Safety Stakeholder Communication website, or PRMIS.phmsa.gov. All right, the Pipeline Hazard Material Safety Administration Enforcement Program, PHMSA, assures the operators of the comply with the PHMS federal pipeline safety regulations through field inspection facility construction project, problematic inspection, operator management system, procedure process with consent investigation through direct dialogue with operator management. To facilitate compliance with the PHMSA, clarify the regulatory expectations, public inspections, forms, protocols, rules, interpretation, posting, final order, website guidance manuals, and advisory notices, FAQ, public meetings, and workshop. PHMSA has available the full range of enforcement tools to ensure the operator takes appropriate timely corrective action. Violations they take preventive measures preclude future failures of non-compliant operation for their pipelines. Finally, PHMSA offers enforcement program provides consideration of operation for small businesses. For more information, Small Business Regulatory Enforcement Fairness Act, nationwide operator specific enforcement reports and records depicting PHM's activities are available at that link. Enforcement program objectives to accomplish this mission. Enforcement programs organized and implemented to meet specific objectives relating to effectiveness. Operator has complete understanding of the PHMS requirement and expectations on identification of program deficiency, either by themselves or by the PHMS work quickly to modify their program. Operators strive to avoid non-compliance in first place with the priority of these compliance issues with highest potential risk. Serious inadequacy, non-compliance are prevented. Operators learn from Spectation findings, enforcement action incident, take corrective actions wide and system wide in order to address latent issues, prevent future issues, identify non-compliance quick, satisfactory, rectified. PHMSA has the accurate assessment, operator industry compliance status efforts, and apparent capabilities, including their timely mitigation, critical safety concerns. Stakeholders are confident that the PHMSA oversight process results in a high degree of full compliance with the regulated community. Efficiency. PHMSA resources are judicially utilized and are directed towards those activities issued highest potential risk. Consistency. Enforcement inspection programs repeatedly lead to the same results given the same similar circumstances. Enforcement mechanisms. Enforcement programs has a number of differential mechanisms to ensure operator compliance and safety operation. Title 49, Part 190, Subpart B, Enforcement Code for Regulations. Brief synopsis of the mechanism provided below. Synopsis does not substitute for the regulations themselves. Enforcement mechanism initiated with the PHMA discuss more detail below and included Corrective action order. The PHMSA determines a particular pipeline facility represented by the hazard to life, property, and environment. The PHMSA can issue a corrective action order. A corrective action order usually addresses the urgent situation arising from the accident, spill, or other significant imminent safety environmental concern. The corrective action order case PHMSA identifies action that must be taken by the operator to ensure safe operation. Specific action depending on the individual pipeline facilities and situation that has created hazard situation or condition. Determination pipeline facility is to be hazardous. PHMSA consider the following: characteristic of the pipe and the other equipment, including its aids, physical properties, manufacturing, construction, information, commodity being transported, operating pressure involved, characteristics, area around pipeline, population, environmental resources, geological conditions, any recommendation, National Transportation Safety Board, any recommendation, National Transportation Safety Board, and any other factor deemed important by the PHMSA Associate Administrator. Corrective action order contains finding pipeline facility or would be hazardous for life, property, environment, and relevant facts supporting finding legal base for the corrective action order. Description or specific corrective action operator must take, the date at which the corrective actions must be completed, the opportunity for an operator to request a hearing in response to option for the corrective action order requires the operator to respond in 10 days, including with the procedure for requesting a hearing. PHMSA believe the condition of corrective action order case exists, but the corrective action order does not need to be issued expeditionally to prevent likely serious harm to life, property, or environment. The operator will be given a reasonable notice and opportunity hearing before an actual corrective action order is issued. In these situations, notice of proposed corrective action order is issued to the operator. Corrective action order is often issued following the pipeline incident. Depending on circumstances, PHMSA may direct the operator to reduce the operating pressure, shut down the the pipeline facility until safe operation can be assured. Pipeline Hazards Material Safety Administration may direct the operator to test the pipeline facility to identify the potential injurious problems as well as take other preventive measures to preclude future failures. Pipeline integrity tasks are required, but the corrective action order may include inline inspection, smart pigging, hydrostatic pressure testing, and additional testing. PHMSA conducts rigorous inspections to ensure that the conditions of the corrective action order are met before allowing operators to return to normal operation. Notice of proposed safety order. In PHMSI finds particular pipeline facility has condition or conditions that pose in pipeline integrity risk the public safety, property, environment. PHMSA may issue notice of proposed safety order, which may require that the operator of the facility take action to address the identified pipeline integrity risk condition. The notice of proposed safety order process proposes specific prevention for the operator that must take an address with identified risks. These can include the inspection, testing, repair, and other appropriate action to remedy identified risks and conditions. The notice of proposed safety order contains notification of pipeline facility with the conditions of those posed in pipeline integrity risks, public safety, property, environment, relevant facts supporting the finding and a legal basis for the notice of the proposed safety order, descriptions of the corrective action the operator must take, date of which the corrective action must be completed when appropriate. The duration of the notice of proposed safety order. Notice of proposed safety order will also provide the operator with response options, including procedure for the request, informal consultation, and a hearing. Operator receiving the notice will have 30 days to respond. Notice of an amendment. If during inspection 3 of the meeting of the PHMSA learned of the operator plan and procedure required with the Federal Pipeline Safety Regulation inadequate PHMA Safety Administration can issue the operator notice of amendment. Notice of amendment specify the alleged inaccuracy, proposed revision to the operator's plan and procedure. Notice allows the operator 30 days following the receipt of the notice to submit written comments, revised procedure request for hearing. Notice of probable violation. Type of enforcement is initiated with the PHMSA depending on safety regulatory significance of the hazard violations. Procedural inaccuracies encountered. Injunction process. The PHMSA initiates enforcement actions through the mechanism listed above to notify the operators of the identified hazard integrity, risk condition, alleged violation, alleged procedural inadequacy, proposed enforcement actions, and finalize with the PHMSA issuance of final order. In most cases, the operator have the opportunity to provide additional information considering content of the written or request of writing hearing to PHMSA notice proposed enforcement actions prior to PHMSA issuance of a final order. Detailed information regarding enforcement response options for the pipeline operator and enforcement proceedings can be found by this link. If PHMSA proposed enforcement action not contesting the facts alleged notice proposed enforcement action is issued in a final order. Consent order. Anytime the PHMSA issues a final order for a corrective action, safety order, or compliance order of the NOPV, notice of probable violation, PHMSA and the operator may agree to resolve the case by the execution consent order. Upon execution, consent order is considered final order. Hearings. In the case of the corrective action order, the operator have 10 days to request the hearing. The notice of the amendment of the notice of probable violation. Operators have 30 days to request the hearing. The hearings are informal, but conducted without strict with adherence with the federal rules of the evidence. PHMSA typically represented with the regional director of the one or more inspectors that were involved during the inspection and preparing the case. Will the operator PHMSA allowed to present the case of the respondent information on the other present with a formal cross-examination during the hearing? Detailed written record hearings are prepared. Operating may submit irrelevant information. Call any witness it believes to support its position. May offer the additional facts, information, explanation, documentation, testimony, other items relevant to the issues under consideration. Operator may also examine the evidence assembled at the PHMSA, determine the alleged violation. Presiding official may also use the PHMSA to respond to rebut information presented by the operator. Each side will be permitted to argue its case in the issues under consideration. Operator may also request the opportunity to submit additional information after hearing to further support its case and address issue raised at the hearing. The presiding officials provide a reasonable time period for submittal of this information. As mentioned above, depending on the specific circumstance, the operator can provide an opportunity for the hearing of the corrective action or if the hearing process is similar to that described above. If the time frames allowed for the response is shorter than situation operator than 10 days after the request for the waive its opportunity for hearing final orders. Once an operator has exercised the response option, which may or may not include a hearing of final order issued for the final step of the enforcement process, the director of the operator to take specific corrective actions and or pay a civil penalty. If the operator waives the right to a hearing, Office Chief Counsel with the PHMSA makes a recommendation for appropriate administrative action for the under a final order. This can either be a compliance order, a civil penalty, or both in case of the notice of probable violation, certain facts of the notice of amendment, order, direct amendment. Also below, if the hearing has been conducted with the presiding official reviews the information providing the hearing, as well as supplemental information supplied with the operator subsequent to the hearing, but not recommended with the applicable final administrative action. In this case, the notice of probable violation result of the final order includes statement defining the determination as to whether the alleged violation has been proved. Final order directs the operator to take the action with the PHMSA and identify the time frame in which they must be completed. Final order also directs the operator to pay civil penalties which are assessed in determining amount of penalty assessed to the PHMS consider the following factors: nature, circumstances, gravity, violation, including adverse impact of the environment, operator's culpability, operator's history of the prior offenses, operator's good faith and effort in attempting to achieve compliance, ethics, effective operators' ability to continue business. In addition, PHMS also causes the economic benefit residual certainty. Other matters of justice may require final order and may also direct the operator to take certain actions identified by the time frame which they must be completed. PHMSA posts all final orders on its website after the operator has paid the civil penalty. The PHMSA region director has confirmed that any of the actions required with the final order are satisfactorily completed. The case is closed. Ordering direct amendment and the notice of the amendment. The after operator has the opportunity to submit with amended procedure to respond with the correct allegation, either writing or hearing. PHMSA demands deemed operator plans and procedures unsatisfactory. Specifically, type of the final order with the call of the operating directing amendment may be issued. An order directing amendment is used if the final injunction contains findings in any of the notice of the amendment case of either dismissing an item or requiring operator to make a specified change within their plan and procedure. The findings are dismissed if the notice of the amendment withdrawn is in entirety. PHMSA final orders include ordering orders directly amendment and see available online. Petition for the reconsideration. Although vast majority of enforcement cases are conducted and described above, regulation provide opportunity for the petition for the reconsider findings and specify for the final order. Such petition received no later than 20 days of final order served. Petition may contain a brief statement of the complaint with the explanation as to whether the action specified for the final order should be changed. Operator may present information to support the petition, must explain with the information presented during and after the hearing. Repetitious administration arguments already considered are not legible reason to petition reconsideration. Such petition is not considered, but filing a petition for reconsideration, civil penalties stated after until a final decision of the petition is made. However, the operator must take any action specified in the final order unless the PHMSA provides otherwise. PHMSA may grant, deny, a whole or in part petition reconsideration without further proceeding. PHMSA must also require additional information specifically to make a determination on the need to revise conditions civil penalties specified in final order. PHMSA renders a decision within 20 days of receiving the petition unless impractical to do so. Criminal penalties. To find out gas transmission pipeline has light liquid truck located near you. The United States Code Pipeline Safety Regulation also specifies the condition under the criminal penalties may be pursued. This include the following: any person willfully, knowingly violates provision of the Pipeline Safety Regulation will, upon conviction, be subject to fine, imprisonment no more than 5 years, or both for each offense. If the person who willfully, knowingly injures or destroys or attempts to injure or destroy any interstate transmission facility, interstate pipeline facility, any interstate pipeline facility, will, upon conviction, be subject to a fine, imprisonment term not to exceed 20 years, or both for each of the offense. Person who willfully or knowingly defaces the damage, removes or destroys any pipeline sign, right of way, marker, marine buoy, will be, upon conviction, be subject to a fine and imprisonment of the term not to exceed 1 year, or both each of the offense. Any person who willfully engages with the excavation activity will, without first using available on-call notification system to establish location underground facility in the excavation area, without considering location information markings established pipeline facility operator. 1. Subsequent the damage of the pipeline result of death and serious bodily harm, property damage exceeding $50,000. Subsequent damage of pipeline facility as known reason for the denial of the damage of the fails to promptly report the damage of the operator appropriate authorities, or subsequent damages of the head of the liquid pipeline facility that result of the release more than 50 barrels of the release of more than 50 barrels of product will, upon conviction, subject to a fine imprisonment of the term not exceeding 5 years or both of each of the offense. Find out the gas transmission pipeline head of the liquid truck line is located near you. Find the national pipeline mapping system. Search out your county and zip code. All right, and that was covering the your PHMSA enforcement program on the pipeline safety stakeholders communications. Testing.